Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about how do you know what's included in your estate. Essentially, your estate is everything that you own at the time of your death. It is a legal definition. Now, when you're talking about probate estate, that's everything that you own in your name alone. So if you own a joint account with your spouse, then that joint account is not part of your probate estate. It automatically by law goes to your spouse as an operation of law. However, it's still considered part of your overall estate when encompassing possibly certain elections that could be done by your spouse. So although initially it's not part of the estate, it's kind of in the background. So what we typically focus on is the home. Is the home titled in your name alone? Is it titled as tenants in common, in which case you and your spouse own 50-50 on the house? Or you and the other co-owner own whatever percentages you own, but you own that percentage? Or do you own that house with your spouse as what we call tenancies by the entirety? Which means in a TBE deed, you're treated as one single person. So when one spouse passes away, the house automatically becomes the other spouse's house. There's no ownership whatsoever by any individual spouse during the time that they're married and own it by tenants by the entirety. However, on the passing of the first spouse, it automatically becomes the sole ownership of the second spouse. So we look at how the house is deeded. We look at how the cars are deeded. Are they deeded jointly or just in the name of the spouse? It doesn't matter what's on the loan documents. We look at how it's deeded. How is it registered with the DMV? Same thing with the house. It doesn't matter who's paying the mortgage or who's on the mortgage. How is the house deeded? That's what's important. Or is the house in the name of a trust, which we often do with our clients. If the house is in the name of the trust, it's not part of your probate estate. However, your items that are in your trust are still part of your overall estate. And we start talking about your federal estate in terms of, are you under that $11.5 million exemption? If your estate value is more than $11.5 million, then you might be subject to the federal estate tax. If your value is less than $11.5 million, there's no federal estate tax because you're underneath the exemption. Now, the estate includes everything that you own, everything that you have any partial ownership in. So if you own investment accounts or have investment properties where you own it with other people, again, we look at the deed. Is it tenants in common, where you each own 50-50 or you each own 1/3? Or is it tenants with right of survivorship? If it's right of survivorship, then when you pass away, your ownership in that property automatically disappears. It's whoever's the last man standing gets it by right of survivorship. They survived, they get the rights. So we always look at the deeds in terms of how things are owned, because that will determine how they fall in or out of an estate. If you have any questions about what is in your estate or would like to have some clarity on that, feel free to reach out to the Johnson Law Firm. Be happy to sit down with you and walk you through your specific examples. Again, you would need to come in and bring those examples with you so that way we can walk you through the technicalities. This isn't really something that can be answered over the phone because it really requires how are things deeded, how are they owned, how is it structured. If you have any questions, reach out to us. Happy to answer them for you.